ABC News.
Hey, good morning. Welcome into Feedback. Attorney Corey Morgan in the studio. Good morning, Corey.
Good morning.
Always good to have you.
Thank you.
We have an email, rather lengthy email question sent to us after we have our first commercial break. I'll read it to you. It says a question for Ask the Lawyer. So I shall ask the lawyer here right after these.
Choosing a funeral home requires enormous trust. This is Joey Young. At Young Funeral Home, we've been earning the trust of Logan Countyans since 1959. Because we are a family-owned funeral home, we understand the importance of treating you like family. We invite you to call us at your time of need or come in and discuss the benefits of pre-planning a funeral with our staff. We create personalized services that honor your loved one. Young Funeral Home with chapels in Russellville and Auburn.
This is Jerry White for Riley White Drugs on the Square in downtown Russellville. I'm here with Donnie Riley to share some exciting news.
Jerry, we are pleased to welcome the newest pharmacist, Dr. Carly Patterson, to the Riley White staff. She's a wonderful addition to our team, and we can't wait for everyone to meet her.
And that won't take long because she's quite the people person.
Thanks, Jerry. I'll take that as a compliment. I am a people person, and I can't wait to meet everyone. After working for a big chain store, I really wanted to find a strong, independent pharmacy that really cared for its customers, just like Riley White. I want to know each customer by name, and more importantly, I want to make certain they understand what medications they're taking, why they're taking it, and how to take it properly. Yes, I'm definitely going to enjoy being a part of the customer-focused staff at Riley White.
Please stop by and meet our newest pharmacist, Dr. Carly Patterson, at Riley White on the Square in downtown Russellville.
And Attorney Corey Morgan here for his monthly Call the Lawyer show. Well, here, this was emailed to us around 8:15 this morning. Had an appointment with a doctor in January and again in July. Due to failure on my part, I did not make payment to the doctor for the January visit until after the July appointment. Payment on the July appointment was made in September. After making the $30 payment in July on the January appointment, I received a bill in September from a collection agency for the January bill. When I contacted them and told them I had paid the bill in question, I also sent them a copy of the canceled check. The collection agency continued to send me bills after that. When I contacted them again and questioned why I was still receiving the bills, they said that the payment I made in July was credited to the July visit and not the January visit. Therefore, the January charge was still considered late and I still owed the collection agency fee. I continue to receive bills from the collection agency and have messages on my answering machine at least twice a week. Am I responsible for paying this late fee even though both bills were paid in full to the doctor's office and the doctor's office is the one who failed to credit the correct bill? Mr. Attorney, how about that?
That is a very good question. I appreciate the detail in which the person had on that. The answer to that is no, you don't owe any late fees. The only time you owe any sort of late fees is when you actually contract for them. If part of the contract that you sign says that you agree to pay late fees, then you'll be responsible for late fees. You won't be responsible for any late fees otherwise. It sounds like to me that you might need to make a personal visit to the doctor to try to work out something on that. And I definitely would not pay the collection agency, or you could send a letter to the doctor's office just saying that both of the bills were paid, because I understand the January bill was paid in July, the July bill was paid in September, so you should be clear. At that point, I would just send a letter to the doctor, send a copy to the collection agency saying that it's been paid in full, and attach the canceled checks. And I would also, if I were you, I would go on the website of annualcreditreport.com. It's www.annualcreditreport.com, and make a request for your credit reports, because you very well might see that collection agency on there. And if that's the case, you want to dispute that charge by sending a letter to the collection, or not to the collection agency, but to the to either Equifax, Experian, or TransUnion, whichever one you're
even if you
with.
don't owe it, that on there, that charge on your credit report could do damage to your credit.
It could,
whether you really owe it or not.
That's correct. And if you send it, to the credit reporting agency that I just mentioned, there are three. There's Equifax, Experian and TransUnion, whichever report you get it from, send them. And it's got on the back usually of the report where you send it to if you want to make a dispute. So you make a dispute that all it has to be is a letter just saying, I dispute this charge because I paid it, and attach a copy of the canceled check. And they'll send it out to the collection agency. If the collection agency can't show that that's incorrect, they'll take it off after 30 days. Mm-hmm. So that's something I would do as well. I would do that anyway. Anybody out there listening, it's free, doesn't cost anything. There's actually a form on that website where you can send in the form and get a free credit report. Or if you want, you're welcome to email me, and I'll just send you a form. I'll email you back a form that you can fill out and send to the credit report and get free credit reports. My email address is Corey Morgan Law, that's CoreyMorganLaw @iCloud.com. If you just send me just tell me you need a credit report request form to request your 3 credit reports, and I'll send it back to you. All you got to do is fill it out and mail it in. You'll get the 3 free reports, and you can see. It won't give you a score, but it'll tell you what's on your report, and anything that's incorrect, you need to dispute to get that off your report.
That reminds me of something. I'm trying to think what it is. Sometimes you might write a check, and instead of it being credited to a larger amount you owe, it's credited to a lesser one, and the bigger one still remains there.
Correct. And when you do that, when you make a payment, write on your payment what it's for, because you have the right as the person who's paying it to have it applied to whatever you're requesting it to be applied to. Otherwise, they need to not accept that. And later on, if there's a dispute, you can very easily see the canceled check where it was to be applied to.
All right.
So that's the best. And sometimes that becomes important because if you make a payment, say, to a creditor, and maybe there's an old bill that's beyond the statute of limitations where they couldn't sue you for. And instead of applying it on something current, they may take it and apply it on that, and then you still got the current bill where they wouldn't have been able to sue you on the old bill. So make sure you put on whatever it is what you're actually applying it to. So anyway.
Well, the lines are open for attorney Corey Morgan locally, 270-726-6100, or long distance toll free 1-888-610-WRUS. That's 9787. The last time you were on, you were teaching one of your Citizens Law School classes, and we weren't able to take any calls that day. But now anybody who there were some who tried to call, and of course we couldn't take them in. And now it's open. We're ready for calls, and by George, here may be one coming in.
Sounds good.
Good morning. This is Feedback. You're on the air with attorney Corey Morgan.
Good morning. Normally I wouldn't complain, but I have to say this morning. A while back when I had a business in town, I paid the EPB, and I paid them by check, and I, in retrospect, watched a woman take my check in the envelope and throw it away, and then they turned my electric off, and I ended up losing my business. Yesterday I was at the phone company, and when we paid the bill, it was paid in 2 different checks. Well, I watched the guy go through the computer and give me credit on one check and made the sweep with his hand to throw the envelope away, and he, just by chance or by habit, I don't know, because he stated later that he always does, but he found a second check in the envelope to pay for it, and he asked me why I was waiting for a receipt if I had to cancel checks. Well, this is 2 different instances where they would, one did and the other one would have thrown my checks away. In the event of the first one, I just lost my business. But on the second one, what is my avenues of recompense on these kind of things?
Oh gosh, that's a very good question, and I don't know of anything you can do really on that. That's one of those. You just gave a very good reason why people need to look at their bank statements and see the checks that have been cleared and versus those that have not been cleared. But I don't know of anything that really you could do. Are you talking specifically about EPB?
I was talking about the local phone cellular company here.
Yeah, I don't know. I don't know what you could do. Actually, just.
The wisest thing my wife does is we have NCR checks, and therefore we would have a copy of what was written on that particular check, and then the photocopy would come back. But in these two instances, they were thrown in the garbage. The actual checks were thrown in the garbage.
Right.
And they would have never, ever appeared again. And we wouldn't have got credit, even though we'd have technically, in a manner, lost that amount of money because we had already deducted it out of our checkbook.
So in both cases, there were 2 checks in each envelope, and in both cases, one check was taken out and another one left in there and thrown away. Is that right?
In the second instance, that was what happened at the phone company. At the EPB, they hauled off and just threw my check in the garbage. I just watched her. She just threw I guess out of force of habit or whatever, she just took my check and just threw it under the desk in the garbage.
Right. I'm not sure what you could do, honestly. I don't know of any sort of remedy
I was
in the law.
I was just wondering if other people had such incidents happen to them. Thank you.
Thank you.
For calling. All right, appreciate your call. Lines are open. You will take your calls. Anything you particularly been thinking about coming over this morning?
Well, I will say this. I put a lot of questions and answers relating to divorce and child custody and visitation and child support on my website, which is actually just a Facebook webpage. It's just what I use because it's real easy to add things to. If you want to go there to look, if you're thinking about divorce, considering it, my website address is Corey Morgan Attorney. That's CoreyMorganAttorney.com. CoreyMorganAttorney.com. If you go to that, you'll see quite a few questions and answers, which I try to give a good summary of what the law is in each of the particular areas, and I'm going to try to continue to put some more information up because I've gotten some compliments from people saying that they appreciate whenever I put information up. So I'm just going to let you know that if that's the case, you might want to check that out.
Good morning. This is Feedback. You're on the air with Attorney Corey Morgan.
Yes, sir. I have a question to ask you. Do you do any child support cases?
I do somewhat some child support cases. A lot of attorneys don't do that sort of work very much. I guess mainly because the child support office is typically the one that's involved in those type of cases. And usually, whenever you have a case that you're dealing with child support, you're dealing with somebody who's the payor of the child support. So yeah, I do from time to time.
Go
ahead.
I have a question to ask.
Sure, go ahead.
Okay. I have been paying child support.
Okay.
I'm 50 years old and still paying child support on my youngest daughter. She's 27 now, but they keep getting me on child support, and her father has never paid child support in his life.
Okay.
I mean, he's working every job in factories here in Kentucky and Tennessee.
Okay.
But they have never got him for child support.
Okay.
We done the blood test, and he is positive the father.
Okay.
So I mean, how do I go about trying to get me a private lawyer or?
What you're trying to do is just make sure that he is paying child support as well. Is that what you're understanding? What you're saying?
I got to be in court, and I was appointed attorney up there in Logan County.
I see.
But I'm trying to figure out why he has never been caught for child support.
How old is your daughter?
27.
27. Is your daughter disabled?
No.
Is this old child support then?
Yes.
Okay. Was there a child support order for her father to pay?
No, that's why I can't figure out why he had never been ordered to pay child support.
Okay, yeah, I don't know. That would have had to have been done a long time ago. They can't go back on it. Child support always goes towards the future. If I were to ask the court to order support, the order is going to be for the future. It can't be for the past. Now, there is an exception to that if the child's less than age 4 and the parties are unmarried and still with the paternity action. They can go back to the date of birth and even require expenses relating to the childbirth of the child. But if the child's age 4 or older, you can't go back on any child support. So it really, unfortunately, and I hate to be the bearer of bad news, but I don't know of anything you can do, ma'am, to get that to where he would pay, unless there was an order previously that he hadn't paid. If there was no order, then he's essentially scot-free on that.
Is a third?
The sheriff's department brought papers to my door.
Okay.
About back pay child support, which when I was working in a factory, they automatically took it out of my paychecks.
Yes, ma'am.
And that's why I can't figure out why they had never caught up with him.
Am I assuming, ma'am, that a third party, someone else, reared the child besides you or some third party? Right.
That's a very good
Her
point.
grandmother, his mother,
I see.
raised my daughter.
So you paid her child support, but he never paid any child support.
And I just got the answer when you said that, and I'm glad Don asked that, because it was his mother who raised the child.
Yes, sir.
Okay, his mother did not want support from him. Guarantee you that's what it is. Because she did not. Most parents, and I'm not saying it's in every case by any means, but most parents will not get a child support order against their child, even when their child should pay, and but she just never got a child support order against him. So therefore, it's just against you. That's why.
Okay, I got another question to ask you. Okay. Sure. She's saying that he's been living in the household, because I had brought it up with another attorney, and they said the reason why that they hadn't got him was because she's been saying that he's living in the household, which he never has. And I mean, what am I supposed to do about this? He's never lived in the household with his mother while my child was being.
Let me put it this way: whoever has the child and is rearing a child is the person who is entitled to child support, and that person is entitled to if it's a third party like a grandparent, that person is entitled to child support from either parent or both of them. It's up to their choice of whether or not they require child support to be paid. So if for instance I'm raising a child that my daughter has, and I can go against the father and require him to pay child support, but I could say that, I don't want child support from my daughter. That's what the law is. It's up to the, because it's for.
But let me ask you this: the caller now, would her child support have been a larger amount because the father is not paying? If he paid, would that reduce the amount of child support she's supposed to pay?
And the answer to that is no. It's your child support would be the same. Whether, they take both parties' income and they add them together and figure out their percentage that they pay. So the child support that the mother would pay would not be affected by whether or not the father paid.
Okay, very good.
So, yeah.
Okay, so I'm working on my disability.
Yes, ma'am.
And I still got to pay child support.
Yes, ma'am.
Yes.
Yeah, it does. Yeah, once that order is entered, it has vested, which means that it can't be changed. It's an order of the court, and that amount's due on child support.
So it's different from Commonwealth and Tennessee.
Each state is different. Tennessee's child support is different than Kentucky's. Our calculations are different.
Okay, so he lives in Tennessee, so. They're not able to get him, right, for child support. No, they could.
There is state reciprocity with other states relating to child support. They could get him for child support. It's just if somebody chooses not to.
If an order was issued for him to pay, they could.
Correct.
Get him,
yeah,
right?
they could. They could get an order. Tennessee has jurisdiction over him, and Tennessee would require him to pay if.
Okay.
Yeah, but that's not it. It's not the fact he was not living with his mom. It's just his mom didn't want support from him. I guarantee that's what it is.
She's asking me for child support.
Correct.
Okay, I understand. Thank you.
Thank you.
Have a good day.
You too. Thank you.
Good morning. This is Feedbacker on the air with attorney Corey Morgan.
Yes, I have a 3-part question, I guess.
Take your time.
What is vehicular homicide? Why? How long does it take in order to charge someone, or that they can't be charged? And how much time in prison would they spend?
Vehicular homicide. Okay.
Now, vehicular homicide. I missed the first part, ma'am. Could you repeat that?
I said, what is vehicular homicide?
What is it?
I always hear of it as manslaughter, but it's being called homicide.
Right. A homicide covers a wide variety of intentional acts that cause the death of another person. It can be anything from murder, where you intentionally kill, you mean to kill somebody, to manslaughter, where you kill somebody you didn't necessarily mean to kill that person. They just did get killed, with whatever action you did. It goes, reckless homicide. That's another type of crime that you could have where you don't intend to kill somebody. It could, it may be, you may be acting reckless. For instance, if I'm driving, through a community, like say I'm going through a housing area and I'm doing 90 miles an hour on my car, and a child runs out and I kill that child. Well, that would certainly be, that wasn't intended. I did not intend to kill that child. It's just because I was very reckless in driving when the speed limit may be 25 and I'm doing 90. Clearly, I'm reckless in my actions, and if I kill the child, that would be, what most jurisdictions would call vehicular homicide, or through the vehicle you kill a child and you didn't mean to, or kill another person. Does that make sense?
That makes sense. But here's the case. My sister-in-law was walking on the road.
Mm-hmm.
She was hit by her neighbor and killed. Now, this was actually 15 months ago.
2 months?
15 months ago.
Oh, 15, I'm sorry.
And now they are charging the boy that hit her
with
vehicular homicide.
Is that in Kentucky?
In Kentucky.
Okay. All right.
And I'm just really not sure as to why he's being charged that. Because he was texting on his phone and he was driving fast.
Right.
But now she was texting on her phone also.
Right.
Now they're charging him with vehicular homicide.
Okay. If you give me just a minute, I'm gonna go into a little more detail into the homicide statutes.
Okay.
And that might be able to help us. Now, Kentucky, let's see, there's a homicide chapter, which is chapter 507 in Kentucky. You're welcome, anybody's welcome to Google it. If you Kentucky chapter 507, Kentucky Revised Statutes, and it'll pull it up. Now, it's got definitions, first of all, of what the law is. And criminal homicide is defined. It says means that a person is guilty of causing the death of another human being under circumstances which constitute murder, manslaughter in the first degree, manslaughter in the second degree, or reckless homicide. Now, those are the four statutes we have for homicide in Kentucky. Some states will have murder in the first degree, murder in the second degree. We don't have that in Kentucky. And I was talking to somebody many years ago. We're talking probably 16 or 17 years ago, that was telling me that the Kentucky penal statutes were based on Michigan's penal statutes. And that, plus it's also based on the model penal code. So that's where they kind of compile the information together. And I frankly don't know if that's true or not. I never cared enough to really get into the research of it, but we only have murder and manslaughter in the first degree, manslaughter in the second degree, and reckless homicide. Those are the four. Okay. Now, murder is, and I'll read this. It says a person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person or of a third person. So keep in mind that says or of a third person. I can try to kill somebody, and instead, say I'm trying to shoot at somebody, and instead it misses that person, hits somebody else, kills a third person. That intent is still there. Even though I didn't intend to kill the third person, it's called transferred intent. So we have transferred intent in Kentucky. It says, except that in any prosecution a person shall not be guilty under the subsection if he acted under the influence of extreme emotional disturbance for which there was reasonable explanation or excuse, the reasonableness of which is determined from the viewpoint of a person in the defendant's situation under the circumstances as the defendant believes him to be. So it's actually not murder if, say I walk in to my wife having an affair and I kill the person. I might at that point be under the influence of extreme emotional disturbance, and that would not actually be murder. It would be a lesser homicide offense. That's a good example of that, or whatever whatever you can. There are a lot of examples I remember from law school about when is somebody under the extreme emotional disturbance. But anyway, then it says, however, nothing contained in this section shall constitute a defense to a prosecution for or preclude a conviction of manslaughter in the first or any other crime. Saying if it's not murder, it may be one of the other crimes. So, and it says, in this second part here is, I think, what you're referring to. It says, B is including, but not limited to, the operation of a motor vehicle under circumstances manifesting extreme indifference to human life. He wantonly engages in conduct which creates a grave risk of death to another person and thereby causes the death of another person. So if you have extreme indifference to human life and you engage in conduct which could create a grave risk of death, and you do, then that would also be murder under Kentucky law. Now,
him using a cell phone or a texting at that time is why they've got him for that?
It's possible. It's very possible, yes. See, I don't know what he's charged with. I don't know if he's charged with manslaughter or if he's charged with murder.
He's charged with murder, homicide.
Well, homicide includes all four of these. It includes murder, manslaughter in the first degree, manslaughter in the second degree, and reckless homicide. Homicide includes all of those. Vehicular homicide just means it's homicide. It's you've caused the death of another person through a vehicle. That's all vehicular homicide means. Now, manslaughter in the first degree says a person is guilty of manslaughter in the first degree when A, with intent to cause serious physical injury to another person, he causes the death of such person or of a third person. B, with intent to cause the death of another person, he causes the death of such person or of a third person under circumstances which do not constitute murder because he acts under the influence of extreme emotional disturbance, as I talked about before in the murder. If there's an extreme emotional disturbance, it may be manslaughter in the first degree instead of murder. And I wanted to mention one thing too. The murder it says down here, murder is a capital offense. That means you carry life imprisonment or the death penalty. We do have the death penalty in Kentucky, so it could cover that. Now, B says with intent to C, through circumstances not otherwise constituting the offense of murder, he or she intentionally abuses another person or knowingly permits another person of whom he or she has actual custody to be abused and thereby causes the death to a person 12 years of age or less who is physically helpless or mentally helpless. That doesn't apply with your situation, but I'm just saying this for all the people out there listening. It says manslaughter in the first degree is a Class B felony. So that would be 10 to 20 years is what manslaughter in the first degree is. Now,
okay, the only other question I have is,
sure.
And my brother did not press this.
Okay.
It was pressed by the state. Is that normal?
The brother did not press what now? Did not press the charges?
He didn't press charges to be brought against the boy.
Oh, yes, that's normal. The state, criminal charges are brought by the state. They do have a victim. A lot of times if the victim doesn't want to prosecute, they won't. But when it's a serious crime such as a homicide offense, the state will prosecute, even if somebody does not want it to be prosecuted. Now, I'm going to read manslaughter in the second degree. It says a person is guilty of manslaughter in the second degree when he wantonly causes the death of another person. And it says wantonly. Wantonly is like an extreme recklessness, essentially. It says wantonly causes the death of another person, including but not limited to situations where the death results from the person's A, operation of a motor vehicle, or B, leaving a child under the age of 8 in a motor vehicle under circumstances which manifest an extreme indifference to human life and which grave risk of death to the child, thereby causing death to the child. Now, you saw that's the operation of a motor vehicle is also included in manslaughter in the second degree. Manslaughter in the second degree is a Class C felony, which is 5 to 10 years. So I don't know if he's charged with manslaughter in the second degree because he was being. I think they would have a hard time convicting him of murder because I'm not sure that just texting and driving is manifesting extreme indifference to human life, especially as much as people tend to do that, even though they shouldn't be. But it might be manslaughter in the second degree, and we also have a reckless homicide, which says a person is guilty of reckless homicide when, with recklessness, he causes the death of another person, and that's a Class D felony, which is 1 to 5 years. That is our homicide statutes. So the question, ma'am, that you have, I guess, is, which one was he charged with, and, whether or not it applies to that offense. And I don't know. It may be the 5 to 10, or it could be, the 10 to 20, or it could be the capital offense of murder. I don't know, what he was charged with.
Well, we haven't done the arraignment yet, so we don't know what he's actually charged with either. He was just arrested.
Right. I see. So was he arrested through an indictment warrant?
Yeah.
Probably? Okay, yeah.
Let me ask a question. Was the victim, did you say the victim was also texting at the time that she was struck, or did I misunderstand you?
Yeah, she was texting at the same time. She was walking on the road and would that in some way
I think it would mitigate the circumstance. I think it would, just because if you're saying that he did something extremely reckless and with disregard of human life, but if she walked out in front of him because she wasn't watching what she was doing, it makes it, she might have walked out in front of him anyway if he was driving. If he wasn't texting, he might have run over. You got that situation up there when you have a victim who is doing something that, puts that victim at more risk, and certainly I understand and have complete sympathy for her and her family and 100%. But at the same time, I'm just saying from a standpoint of prosecuting a case, it makes it a little more difficult to prosecute when you have that sort of thing if the victim is engaging in behavior that may have caused an accident anyway. So, yeah.
See, that's our point, and we're devastated that they actually waited this long and now have charged the young man.
Sure.
Even as her family, we don't want to see harm come to him for something we really don't want to see.
You're breaking up a little.
Right, it's hard to hear you, ma'am.
The phone is sort of acting.
I'm going through an area where you can't hear me.
Okay, all right. Well, thank you.
Thank you. Another thing I want to mention regarding that, what the victim's family wants comes into consideration. If they're contacting the Commonwealth Attorney's Office and going, look, we don't want this guy prosecuted, sometimes when you prosecute people for things that they didn't intend to happen and are heartbroken that they did happen, it devastates two families rather than just devastating one family. So, the Commonwealth, a good Commonwealth attorney will take that into consideration. A good judge will take that into consideration when the judge is sentencing, and whether probation is appropriate or what. It depends on the conduct. Criminal law is so fact specific that one little fact can just totally change the entire aspect of the case.
Lines are open. Somebody was trying to call a while ago and they bailed out. Called us right back. We'll have a commercial break. Attorney Corey Morgan will answer your questions. We'll be right back.
Should I repair or replace my existing system? How much can I save with new equipment? Is installing a central HVAC really necessary? There's so much to consider when it comes to heating and cooling systems. Fortunately for us, the professionals at Knight Electric Heating and Cooling serve the entire WRUS listening area. One call and they do it all. Call 270-726-3818 and put the power of Knight Electric Heating and Cooling to work for you. Of course, they provide free quotes on new systems and even offer 24/7 emergency services for your convenience. So if your unit dies during the middle of the coldest night or hottest day of the year, don't fret. Call the expert technicians at Knight Electric Heating and Cooling. Are you calling yet? 270-726-3818 and ask about any of their fantastic services today. Knight Electric Heating and Cooling, license number MO4318.
In most cases, an automobile is the second largest purchase a household makes. When you're spending thousands of dollars, you want to be sure that you're getting the best deal possible. At Freeland Chrysler Dodge Jeep Ram, you have a friend in the car business. Right now, special incentives make it easier than ever to own a hardworking Ram. Like the new Laramie 1500 Crew Cab 4x4. This truck features a 5.7-liter Hemi and smooth 8-speed transmission. The sticker says $49,590, but at Freeland, rebates and discounts save you $10,582, making your friendly Freeland price $39,008. Plus, no dock fees ever at Freeland, saving you hundreds more. Freeland Chrysler Dodge Jeep Ram, where you have a friend in the car business. Shop online 24/7 for the best deals in South Central Kentucky and Middle Tennessee at FreelandCDJR.com. Freeland Chrysler Dodge Jeep and Ram, 1451 Bowling Green Road, Russellville, Kentucky.
Stock number 812005, tax and license not included in sale price.
Save more when you shop close to home this week at your Russellville Piggly Wiggly store. Tackle these super savings before the big game. Family pack fresh ground beef, $2.79 a pound. Whole Boston butt pork roast, only 99 cents a pound. Pick up Idaho potatoes in the 10-pound bag, $2.99. And Del Monte Gold pineapples, 2 for $3. Hunt's Sandwich Sloppy Joe sauce and the 24-ounce bottle of Hunt's ketchup, only 99 cents each. Totino's Party Pizza selected varieties are 10 for 10, and Kraft cheese, shredded chunk, cube, crumble, or cracker cuts are 3 for $5. Don't forget sweets for the big game. Wesson Pure Cooking Oil, the 48-ounce bottle, 2 for $5. Betty Crocker Brownie or Cake Mix, only 99 cents. And Domino Granulated Sugar, the 4-pound bag, is 2 for $5. Stock up on Nestle Pure Life Purified Water. The 24-pack bottles are 4 for $10. You'll save more when you shop this week at your friendly and convenient Piggly Wiggly in the Bethel Shopping Center, Russellville.
Well, the phone lines are open now. You can talk with Attorney Corey Morgan locally, 270-726-6100, or long distance, toll free, no charge, 1-888-610 WRUS, WRUS 9787. Anything else you want to mention what you were talking about, or something crossed my mind? Is anything?
Oh, go ahead and ask me.
Well, I was thinking about the mom who did not want her son to have to pay child support. Makes me think of the affluenza mom a little bit.
Oh, right, yeah.
This is she. The guy was drunk and drove and killed 4 people, but he got probated.
Sure.
With the argument, caller, stay on the line. We'll take your call. Don't go away. With the argument that he had been so spoiled, he just didn't know right from wrong. So he goes to a beer pong party, violates apparently his parole, and then his mom runs off with him to Mexico.
Yeah, that's the epitome of enabling. I don't think I've ever heard enabling quite that bad. And you see that from time to time, where you have parents enable their children, and parents out there who are listening, please do not enable your children. Do not suffer the consequences for them. Let them suffer their own consequences, because it makes it to where they don't. You have to pay for your. There has to be a cost for your actions, and if there's no cost there, then you don't ever change your actions.
They ran up to Mexico, and he ran up a $1,000 or $2 bill, something with strippers and booze. Correct. And his mom, they followed him to the hotel, and his mom had to pay that. And she actually may face more time than he would because of being a juvenile, right?
Yeah, I would say so. Yeah. I think that's accurate.
Okay. Good morning. This feedback. You're on the air with Attorney Corey Morgan.
Yes, I was wondering, my husband and I have had our grandson for the past 3 years. He's 6 years old now, and all through his life, we've pretty much had him, but at the age of 3, his mother was constantly in and out of the court system in the jail.
Right.
And the last time we went and got emergency custody, and they called that an ex parte.
Ex parte?
Yes, okay. Anyway, when she got out of jail, they had requested that within a month that she could come in and, we would go over it again. It would be reviewed. Well, she never did that. She actually abandoned and left for another state.
I understand.
Several miles away.
Yes, ma'am.
And she has only contacted him as far as visitation, 15 minutes one summer and maybe an hour this year before Christmas. She has bench warrants against her here in Logan County for not appearing in court. She's non-supportive. She has not contributed anything.
Yes, ma'am.
And I was just wondering, does she have any right?
Well, let me ask you, what are you referring to specifically as far as does she have any rights? Does she have any rights to see the child?
No, does she have any rights to come back and try to take him back?
Okay, this is going to...
He is established in this home, in school. He never speaks of her. He does have a father that, that is active in his life and helping to support him. He is crazy about his father. But she is almost non-existent. But I'm afraid out of revenge that, she may come back someday and try to.
Okay. And I understand where you're coming from. This is going to be a little bit of a lengthy explanation, okay? But in answer to your question, yes, she can come back and ask the court for custody or for visitation, but it's unlikely that she will get it. She will get visitation, no question about that. Parents, courts are very reluctant to restrict parents' visitation. Sometimes they make it supervised. Sometimes they make it, to where it has to be under certain conditions. But they do not outright deny visitation. In fact, they really can't unless there's some sort of serious endangerment to the child that's going on. Now, whenever you have a parent versus a non-parent, the general rule is parents always win, unless the non-parent can show that the parent has either waived their superior right to custody or is unfit. Unfit meaning unable to take care of the child in danger to the child. Now, what I mean by waive superior right to custody, by virtue of being a parent, the U.S. Supreme Court, as part of the liberty you have, the liberty interest you have from the United States Constitution, you have the right to raise your own children. That is a liberty right that all parents have. Now, that liberty right can certainly be taken away, or it can be given up. If I give my child to somebody else, I'm giving up my liberty right or my superior right to have that child over the rest of the world to somebody else. So that's where it gets involved. Kentucky has also, in addition to that, they have something called a de facto custodian. A de facto custodian means that you have been the primary caregiver and financial supporter, not or, it's and financial supporter. It's conjunctive, not disjunctive. Primary financial supporter, primary caregiver of a child. And if the child is 3 years of age or less, for 6 months. If the child is over the age of 3 years, for a year. If you meet those definitions, primary caregiver, primary financial supporter, child is less than 3 at 6 months, more than 3 it's a year. If you meet that definition, you are a de facto custodian. And de facto custodians are, under Kentucky law, they have parental standing. You're just like a parent. You have the same standing as a parent. That means that if she comes in and says, "Oh, I want my child back," she has no more right to get her child back than anybody else does, because it's a parent versus a parent. Because you all, I guarantee you, are de facto custodians, and because of your status as de facto custodian, you have the same rights to that child as she has, which means that she has to show somehow that it was in the best interest of the child for the child to be returned to her when she has led this unstable life, this life where she's going state to state and she's unable to take care. It sounds like she's unable to take care of herself, much less a child. The likelihood of a judge giving the child back to her in the circumstances is almost remote. In fact, if a judge did that, the judge needs to be taken off the bench if you're giving a child to somebody who's putting that child in danger. So in answer to your question, she can ask for anything. You can ask for the world. In fact, if you go to court, I think it's a good idea to ask for more than you're really wanting to get, because it does help. It's just like a negotiation, somewhat. If I ask for more than I'm expecting to get, if I get less, I'm really trying to get what I was wanting anyway. So, the answer to your question, you have the right by being. She has not lost her parental rights, okay, and because of that, she can always come back. But you, by virtue of having rights to this child, you can ask for child support from her and have a child support order. Just like the caller before, there was no child support order, but in your case, if you want a child support order, you can certainly get one, because children need to pay. I should say parents need to pay for their children. And if it's a third party that has the child, then certainly you want to make sure that child is taken care of. Does that answer your question?
I think our caller hung up to listen on the radio.
Okay, that's fine.
All right, we'll take our final commercial break. We'll be back.
Thank you.
We can take your thanks for the call. Caller, stay on the line. Don't go away, caller. We'll be right back after these messages. Just stay with us, okay?
This is Jerry White for Riley White Drugs on the square in downtown Russellville. I'm here with Donnie Riley to share some exciting news.
Jerry, we are pleased to welcome the newest pharmacist, Dr. Carly Patterson, to the Riley White staff. She's a wonderful addition to our team, and we can't wait for everyone to meet her.
And that won't take long because she's quite the people person.
Thanks, Jerry. I'll take that as a compliment. I am a people person, and I can't wait to meet everyone. After working for a big chain store, I really wanted to find a strong, independent pharmacy that really cared for its customers, just like Riley White. I want to know each customer by name, and more importantly, I want to make certain they understand what medications they're taking, why they're taking it, and how to take it properly. Yes, I'm definitely going to enjoy being a part of the customer-focused staff at Riley White.
Please stop by and meet our newest pharmacist, Dr. Carly Patterson, at Riley White on the square in downtown Russellville.
This is Joey Young of Young Funeral Homes Incorporated. When you lose a loved one, a number of details must be worked out in a relatively short amount of time. The pressure of these decisions is only made worse by the grief the family is feeling. Since 1959, our community has trusted Young Funeral Home to help them through this difficult time. We create personalized services that honor your loved one. As a family-owned funeral home, we understand the value of family and know that's how our friends and neighbors deserve to be treated. Young Funeral Home with chapels in Russellville and Albany.
And good morning. This is Feedback. You're on the air with attorney Corey Morgan.
I just have one question. If there were two people, they had a baby, they were never married, and the mom was supposed to court order to put the name as the father's name, her maiden name, the father's last name.
Mm-hmm.
Twice court ordered, and never has done it, and it's been years.
Mm-hmm.
The kid's still of 13.
Mm-hmm.
Does he have to go back to court to get that changed, or what does
yes.
he need to do?
The answer to that would be yes. You need to. It sounds like one of the problems with a little bit, yes. One of the problems with being on the radio is I can't see any documents. If you don't know, there's a couple different ways that might have happened. If it was a separate order that wasn't in a name change.
It was agreed by both of them to do that.
Okay. And was it in district? Was it in district court?
Yes.
Okay.
Yes.
I'm thinking, and certainly don't hold me to.
Dad went to paying child support, paying insurance, and everything.
Right.
He went to school one day, and they didn't even have any record of him being her dad.
I see. Well, it sounds like you got a few things going on there. There's been paternity established, you're saying?
Yes.
Okay. There'll be a paternity order then, and he'll need to take that order to the school. Is it joint custody? Is there any sort of custody award at this point?
I think she's got it's joint custody, but they're having primary.
Okay. That joint custody order needs to be taken to the school. That way the school has record of that. And I will also allow him to have access to school records. Okay. And as far as you're looking to, he's probably going to have to bring a name change for a minor child and attach that order to it. That's what I would do on that, because there needs to be a name change order that's signed showing that the child's name is changed.
Okay.
And then you can take that name change order, a certified copy of it, and send it to Frankfurt and get the birth certificate changed.
Oh, okay.
See what I'm saying? Because you want the child's...
Because it's nothing's ever been done.
Right. It needs to be done.
And he just try to kind of keep it, calm and cool. He's always done that. And things have been okay, but, still, that's just one thing that kind of bothered him.
Understand. So. District court has jurisdiction over name changes. Okay. And you can get the paperwork from the clerk's office at whichever courthouse that the child resides in.
Okay.
I should say whatever courthouse of the county the child resides in. And just go there, get that from them, and you fill it out, and it'll have in there, what the former name is and what you want the name to be. And just make sure when you file it, you file a copy of that order saying that it was going to be that it was ordered to be changed.
Okay.
That way the court will see that and say, oh, well, that was something that's already been ordered.
Right, yeah.
And it's just a matter of carrying out that previous order.
Okay.
Okay?
All right. Thanks much.
All right, thanks
you.
Thanks
for calling. Good morning, this is Feedback. You're on the air with attorney Corey Morgan.
Yeah, I got a question.
Sure.
My stepdaughter, she is divorced from her ex-husband for, a few years now.
Sure.
But when the kid goes down there, he's over 6 months behind in child support.
Mm-hmm.
He tells the kids that if it wasn't for him, they'd be on the streets,
mm-hmm.
That your mother doesn't do anything for you, and blah, 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 blah.
Mm-hmm.
And he does everything. He fills the kids full of negativism,
mm-hmm.
like the son. He doesn't want to really go to school, and his dad says, well, you're overqualified for school. So he kind of feeds into him, but it just creates an issue, and he sends, of course, nasty texts
mm-hmm.
and everything. Is there anything that she can do to get, she doesn't want to keep the kids from him or anything of this
sure.
nature, but
mm-hmm.
he's doing wrong by the children
mm-hmm.
by feeding them this crud, and it's got them so confused. They don't know whether they're going up, down, left, right,
mm-hmm.
or what.
Sure, I understand exactly where you're coming from. I see that from time to time. Unfortunately, the only thing you can do is go to court, but the court will, most judges I know would come down on him very, very hard and say, if you continue to do this, you will have no visitation whatsoever. They would enter orders. We have something the judge here in this county and the judge and judges in other counties will do called a do-good order, where it said, has certain things that you have to do, and that's, not talk bad about the other party, not, essentially feed, just what you're saying, feed the children's head full of things. That's clearly inappropriate to say, you'd be out on the street and that's something judges typically would rather have no visitation than have visitation with somebody who's is saying those sort of things. Not only do you need to go to court, but you need to make sure that you have the evidence too. So whatever text messages that she receives, she needs to save those.
Mm-hmm.
And I'll say those for people out there. Sometimes I have to tell people, hey, if you're saving text messages, and they'll say, well, I don't know how to do that on my phone. Well, what you do is do a screenshot of the text messages on your phone and email it to yourself. If there's no other way to save it, just do it that way. And that way you've got it in an email to yourself, and what you can print out to show the court the text messages that were sent by the other party. Of course, this goes without saying, but I'll say it anyway. Do not mess with the text messages. Don't delete or add or do anything to that needs to be exactly like it was when it was received.
Keep it whole.
Keep it whole. Don't miss any. Don't take a screenshot and then go down a few texts and take another screenshot. Take all of them to where it's clear that all of them are there. When you do that, and because that will be certainly evidence in court that you want to present to show that there's some shenanigans going on that needs to be corrected, and the judge will address the visitation. If he continues to do that, the judge will just shut off visitation or make it supervised, make it one of these places that like in Bowling Green where you go and you can have visitation for a couple of hours where somebody's watching you. That's
right.
The sort of thing that the judge will do if that sort of thing continues.
Well, he was supposed to cover the kids with insurance and everything.
Right.
And one of them had to have some minor surgery,
mm-hmm.
and he produced an insurance card that was not valid.
I see.
He had quit his job.
Mm-hmm.
He still posed as though he had insurance on the children,
mm-hmm.
and they took it. Well, now, guess what?
Mm-hmm.
The daughter is getting letters from the hospital and the doctors that they haven't gotten paid, that there's no insurance, and
mm-hmm.
they're wanting her to pay. Would be the status of that for him producing it?
You got a minute, Corey. Go ahead.
I'll do this very quickly. That is a court issue. You're going to have to go to court. Going to ask him to be held in contempt for violation of the previous order, which says he's supposed to carry insurance, and ask him to be required to pay. I would say go to jail or pay. That's your two choices. And I would address the visitation issues as well, and ask the visitation to be restricted. And then, whenever you go to court, you want to ask for everything that is an issue. You don't want to piecemeal it. You want it all together at one time so the judge can hear all the problems of the case and make one order on that. So,
Corey, great to see you.
Thank you.
Be looking for you in March, right?
Sounds good. Thank everybody for calling.
Appreciate your calls. Interesting calls today. Attorney Corey Morgan with us today, dispensing free legal advice here on the Feedback Show. I want to mention this. A wide wheelchair was stolen Saturday from a vehicle on the Walmart parking lot in Russellville. The owner really needs the wheelchair back. If you know anything about this wheelchair theft, please call 270-755-5593, 270-755-5593. ABC News here on AM 610.